Mr. Deeb?
Does that jail time credit include the original case or just this case? Your Honor, I was asking about the jail time credit since this was a refiled case. I believe there's an extra day. And as I thought about it, he was just arrested the one day, and no, 2 days credit, because they arrested him that day and then he found out the next.
So 5 days jail time credit?
He got out at like 6 or 7 the next day after seeing the parents. So,
Your Honor, we would agree to 5 days jail time credit.
Okay.
thank you, Your Honor. With that, we are ready to proceed to sentencing. Your Honor, we would ask the court to consider judicial release in this case. We know that there's mandatory prison. In his prior OVI in 2014, he received a 2-year plus the mandatory minimum of 3 months. I was going to ask the court for an 18 to 24-month prison sentence that would encompass that 24 days. Obviously, the license suspension and fine are mandatory. But what I was going to ask the court, given the fact that his history is over such an extended period of time, putting him in prison, he'll do his time. He'll be a model inmate. He responds to rules other than the OVI laws very well. He's very likable. I'm sure that people will like him when he's down there. But it's not going to do him any good. He could get his GED while he's down there. He can take programs. But being in prison, those programs aren't nearly as qualified as, say, an IOP or any other programs that would be something that could immerse himself in here. And that would give the court the opportunity to supervise him, have him do programs, but also make him productive, get back to work, get back to his family under that supervision. But he still has to pay the penalty, which would be incarceration. So I propose that to you. If the court were thinking 2 to 2.5 years, or what the court was thinking, extend the prison time so that he would have more time hanging over his head, but consider giving him judicial release after 12 months or so, whatever the court would deem fit. And that way you could tailor a community control sanction package that would rehabilitate him much more sufficiently, or put in certain rules in place that will help him and protect the public rather than just pause everything. Dennis is a very likable guy. Unfortunately, he put himself in this predicament, and he did finally come clean after everything was said and done. But at this point, I think that him rehabilitating himself is the most important thing in Dennis's mind, so that he doesn't put himself back in this jackpot, because he will be getting out. He's taken steps in his life to ensure that his family, the hardship on them is minimized. But he does have the opportunity when he gets out, so that he will be back at work in another good job, being the yard supervisor for the construction company. And with those things being said, even though recidivism is obviously a problem, just letting him languish in prison doesn't really serve much purpose other than just to pause his interaction with society. Thank you, Your Honor. Wait until he dresses you.
These, we had a trial on just 3 charges, right?
Yes, Your Honor. It was count 1, the A1A count, and then count 4 was renumbered to count 2, so that should be the refusal count, and count 5 was renumbered to count 3, that's the misdemeanor count.
Okay.
That's the failure to comply, 6 months or 6 points.
Failure to stop.
Yes, and it carries a mandatory license suspension also.
All right. So 1 and 2 do not merge?
Your Honor, we would elect to proceed on
Okay.
count 2.
All right. So we're proceeding on counts 2 and 3. All right, Mr. Boyd, what do you want to tell me?
Well, Your Honor, I just would like to apologize to everybody involved. I am truly sorry for it. I made a terrible decision that afternoon to have a few drinks after we got done working. I didn't think I was that impaired, but like the prosecutor said, that it does delay your reaction time and those types of things. And it was just a terrible mistake on my part. I'd just like to apologize. After I got out of my last one, a lot's changed for me. I went back to work. I reestablished my credit. We bought a house. and I was doing everything that I was, supposed to be doing. And my wife and I, we have a great relationship. I'm a grandfather now. And I'd just like to have you take that maybe into consideration for the sentencing.
The question is, why have you been doing the same thing over and over again for 30 years?
Sir, when I was younger, I honestly believe I was just I felt entitled to be able to stop and have some drinks after work with the guys on occasion. And I realized it was a huge mistake. That I stopped doing. I honestly did. I don't hang out in bars or anything like that. I just go home, spend time with my family. I don't very rarely hang out with friends anymore. I just hang out with my family, and that's, I would say, the biggest change for me in the last 10, 12 years. And before I was just hanging out with my friends all the time. When I get out of jail, I have a job offering. One of the guys called me that I used to work with and wished me luck in court, and he's offered me a job. He says, when you get out, he says, all we have to do is get you to and from, and you'll have a job when you get out. Don't even worry about work, and so I can get squared away with my fines and restitution and whatnot.
Doing what?
There's a construction company. They want me to work in the yard, organize things like that, get trucks ready to go in the morning. Just a yard manager, more or less. Make sure there's inventory.
Well, when you testified here at trial, you indicated that you hadn't had anything to drink until you got home, and then you killed half a bottle or so of Jim Beam.
Yes, sir.
Which was not true, right?
I did drink before I got on my bike. Yes, sir.
So, with regard to that, you told Ms. Knaus that you were doing some additional stumps, and whoever wanted you to do these additional stumps brought a 12-pack, and you had 3 beers while you were
yes, sir.
killing those stumps, right?
Yes, sir.
Okay. But you told Ms. Friend, the drug and alcohol evaluator, that you stopped on the way home and drank.
No, I didn't. I don't remember telling her, sir. I don't remember saying that.
Well, you've got 8 prior OVIs. One's a felony back in 14.
Yes, sir.
And a physical control. These OVIs start in 94. You got a 94, 96, 98, 2000. 01, physical control in 05, 06, 08. And then you got a 6-year break. You get your felony in 14 in Geauga. And now this thing has occurred in 24, so you have a 10-year break. So why did you have these breaks of 6 and 10 years between OVIs?
Well, I had stopped drinking for periods of time. Like I said before, when I started drinking again, I would just go home. I wouldn't. That's all I would do.
Well, hopefully you've gotten to the point where you can quit bullshitting yourself that you're okay to drink as long
Yes,
as
sir.
you're at home or anywhere else, because obviously you didn't do that.
Yes, sir.
You didn't confine it to that. So, I don't know, this seems like first of all, you got lucky that nothing else happened. Okay. Second of all, this is also unnecessary.
Yeah. Yes, sir.
All right, anything else you want to say?
I'd just like to apologize again. That's all, Your Honor.
All right, Ms. Tuttle?
Thank you, Your Honor. The state would request that the court impose a mandatory prison term here as is required by law. The mandatory minimum here would be 120 days of prison on count 2. The state would also request a mandatory fine of between $1,350 and $10,500, mandatory drug and alcohol programming, a license suspension of at least 3 years to life, and the defendant to forfeit the motorcycle that was registered to him at the time that this incident occurred. It's clear that the defendant has a long history of committing these offenses, as the court has outlined. We would additionally ask the court to impose a sentence on the misdemeanor offense concurrent to whatever the sentence is on the felony OVI. Thank you.
All right, I've reviewed the pre-sentence report, the drug and alcohol evaluation. I've listened to Mr. Boyd, listened to counsel, considered all the provisions of 29, 29, 11, 12, and 13. And as Ms. Tuttle indicated, this is a mandatory prison case because of the nature of the history here. And so on count 2, I'm going to impose a prison sentence of 54 months with credit for 5 days. Impose a mandatory fine of $1,350. You're to undergo mandatory drug and alcohol treatment. I'm going to suspend your driver's license for 5 years and order the forfeiture of the motor vehicle or the motorcycle. And on count 3, I'm going to impose a jail sentence of 180 days, which by law is concurrent to count 2. Anything further, Ms. Tuttle?
No, Your Honor.
Mr. Deeb?
Do you have to impose a license suspension on the failure to comply? Or not the leaving the scene?
I have no idea.
I know it carries a mandatory suspension. That's why I was wondering. I think you have to order it.
I believe it's a minimum of 6 months.
Okay, 6 months.
Nothing further, Your Honor.
All right.
All right.
Good luck, Dennis.
Oh, yeah. Hold on. Good catch, Kathy. Since you were convicted at trial and sentenced, you have a right to appeal the conviction and sentence to the 11th District Court of Appeals. You have a right to have a lawyer represent you in the appeal. If you can't afford one would be appointed. You have a right to the transcripts. If you can't afford the transcripts, they would be given to you free of cost, and you have the right to have a timely notice of appeal filed on your behalf. All right?
Thank you, Your Honor.
Thank you.
All rise.